Good afternoon, friends. Thanks to Sagar. We are here to discuss this topic of Information Technology Act 2000, basically taking a relook at this 20-year-old legislation in India. Uh, Before we start, perhaps Sagar, should we have our first poll just to understand where we stand?
Sure, I'll just roll out that code.
Yeah. Just want you to reflect what is, in your opinion, the nature of this law called Information Technology Act 2000. Is it a cybercrime law for India? Is it the contract law for the digital world? Is it the data protection law? Is it the cyber security law of India?
Yeah,
Or is it all the above?
yeah. So, missionary, it's taking just a couple of minutes for the poll to roll out.
Okay.
I
Okay.
think,
Yeah.
so I think we can start off with the session and I'll roll out the poll in between.
Okay. Okay, fine. Shall I go ahead?
Yeah, please.
Yeah. So, as most of you are aware, this Information Technology Act 2000 was notified on 17th October 2000, and at that time it was envisaged as an e-commerce promotion law. That is, worldwide people were moving to the use of e-commerce in business without a proper foundation of a law. Therefore, the United Nations suggested that a law has to be passed by all the sovereign countries to enable e-commerce to happen with a certain legislative foundation. So that was how Information Technology Act 2000 was conceived and brought in to India. We were one of the earliest countries to have passed such a law. Subsequently, in the year 2008, there was a major, you can say, amendment, upgradation of the law um, through a bill passed at the end of December 2008, but actually came into effect on 27th October 2009. Let me just ensure that it doesn't uh, remain like that. Okay, 2009. So the law was enacted with effect from 27th October 2009. At that time, this section called 43 capital A became part of Information Technology Act. And today we are talking of taking this 43A out of Information Technology Act like a demerger and then creating a new law called Personal Data Protection Act. We hope it will be passed within 2020 because the bill is overdue for passage. So it may be called PDPA 2020. That will be the Data Protection Law of India. So you can see that this data protection law will be a continuation of the Information Technology Act, and it is born out of the current provisions of Information Technology Act. Now this bill came into being in the year into December 2019, and there is a period between that December 2019 and today and until when this bill is passed, when we have a situation where we know 43 capital A is going to be converted into PDPA 2020, but in the books today 43A remains, and Information Technology Act talks of a concept called due diligence, concept called reasonable security practice, and 43A represents that reasonable security practice. And if 43A, one single section, becomes 98 sections under PDPA 2020, then these 98 sections become part of Information Technology Act as due diligence or reasonable security practice. That is the special situation which we are in as of today. So today we can look at Information Technology Act, the 2008 version, as a compendium of law of digital contracts, law of cyber crimes, and law of information security, whereas the law of privacy protection will move out of Information Technology Act into PDPA 2020. Even when this happens, Information Technology Act will remain relevant because the Personal Data Protection Act will focus on compliance of certain regulations, so that there will be certain requirements of security practices, privacy protection practices, etc. But in terms of providing punishments for cyber crimes, even if it is related to data related, personal data related offenses, Information Technology Act will continue to be relevant. So we cannot say that because PDPA will come, Information Technology Act will become less significant. In fact, it will continue to be significant. Part of its current significance will be moved to a separate legislation. So that is what we are going to see as this new act comes through. Now, when we look at the Information Technology Act, therefore, we will be having these three specific, you can say, the dimensions of Information Technology Act. One is that it will be the law, it has been the law, and it will continue to be the law, which provides legal recognition to electronic documents. Now, when it gives legal recognition to electronic documents, along with that, it provides legal recognition to some form of signing an electronic document, which we call as the authentication. We come to a situation where electronic documents can be used as an offer document or an acceptance document for creation of digital contracts. That is the reason why we recognize that Information Technology Act is the law of digital contracts. But we also have a contract law called the Indian Contract Act, which has more details about what a contract means, etc. So the law of digital contracts will be partly determined by Information Technology Act, and of course substantially determined by the Indian Contract Act. So Information Technology Act, apart from addressing legal recognition of electronic documents and legal recognition of the way an electronic document can be authenticated, it has also touched upon a few points which perhaps cannot be directly addressed or could not have been directly addressed in 1872 Indian Contract Act in whatever manner it could have been done. So the Information Technology Act talks about the attribution of an electronic document, that is, who is the person to whom the responsibility of a given electronic document should be attributed. So, who is the person who is signing the offer document? Who is the person who is accepting the document? So, that kind of attributing a given electronic document to an identifiable human individual for the purpose of legal responsibility, that is called attribution. And Information Technology Act specifies who is considered as responsible. This is very much important in the electronic circles because many times the activities which are normally done by human beings are substituted by the machines. Okay, so there are e-commerce servers which will automatically give out a response. So when you send an email, either it will say that the person is not available or whatever is that, or sometimes it will say we acknowledge your request or whatever you have sent, and action will be taken, something like that. And there are ways by which we are automating many of our activities, and the more and more automation is there, the public or any individual will be interacting with machines and concluding what we can otherwise call as contracts. Now, if you start looking at artificial intelligence, the blockchain technology, smart contracts, you know that the technology is moving towards doing things through automated means. So, Information Technology Act, way back in 1998 when the first draft was formed, 2000 it was passed. But 1998, when the first draft was written, even at that time, gave this element of what is called an attribution and said that when a machine responds automatically to any message, then that response will be attributed to the human person who caused that computer to behave in such a manner. Therefore, in India, we don't have a machine being contractually involved. Whatever the machine does, it will be attributed to the person who caused the machine to act in a particular manner, which may be the owner of that system for the time being when the contract has been struck, or maybe even the software developer who automated the particular software in such a manner that the owner may not even know what the software is doing. See, I may buy a software with certain default configurations which only the developer knows. Now in the manual, the developer has not told me what exactly are the default configurations. So I buy it thinking something it will do functionally. But let us say it does something automatically. Now the question comes, who is responsible for this automatic functioning, which could be a crime in certain cases? It could create liabilities. Now, prima facie, it will be on the owner of the system, but it is quite possible that you may put up an argument that when this software was transferred to me, the manual did not tell me what was the default configuration. So the default configurations and certain actions of the software are still owned by the seller of the software or the person who has configured the software. Therefore, the responsibility should be taken by that person. This kind of possibility exists in the Indian cyber law. The other part which this act has specifically addressed is how do we determine the time and place of a message, because sometimes time and place of sending of a message or receiving of the message will determine the jurisdiction of a contract. Similarly, when some message is sent, whether it will be effective immediately or whether any acknowledgement is expected from the other end, and this message will become effective only when the acknowledgement is given. These are some of the issues which Information Technology Act has specifically addressed. But rest of the contractual requirements, like what do we mean by a contract, an agreement which is enforceable in law, and enforceability depends on whether the consent was given freely by the persons who are involved there, whether the contract is for a lawful object, lawful consideration, etc. And documentation wise, is there an offer, is there an acceptance? Of course, the Indian Contract Act says that apart from the documentary contracts where there is an offer and an acceptance, there can be oral contracts also. Sometimes the contracts can be implied by the circumstances of the transaction, and they are called implied contracts. So all these things are available in the Indian Contract Act, which has to be read along with the legal recognition of electronic documents and legal recognition of the method of signing and this attribution, time and place of the message, etc., which are specifically addressed in the Information Technology Act. Now, if we want to just for a moment go into what is an electronic document, because legal recognition of electronic document also means the law has to explain what is an electronic document. So the Indian law suggests that electronic document means something which is in a binary expression. That is, if you are expressing some thoughts or information in a binary format, then that is called an electronic document, and that is equivalent to paper document in most of the cases. Okay. Now, this binary expression can be on a hard disk, it can be on an SSD, it can be on a, let us say, CD. So depending upon the media which is used for representing a data, the electronic document may be a sequence of zeros and ones, starting from something, ending with something. All are combinations of zeros and ones. In some cases, it may be the magnetic charge of the surface, which is broken up into different pixels or small areas, and we say this particular area is positively charged, this particular area is negatively charged, something like that. Or as in the case of a CD, it may be some depressions and planes. So there are various ways of expressing the binary documents, but those documents which are so created through impulses and read through certain equipments which we call as computers, they are called electronic documents. Out of such electronic documents, if there are documents which can be called as negotiable instruments other than the check, or a power of attorney, or a trust deed, or a will, or a document which actually is supposed to transfer interest in immovable property, such electronic documents are outside the provision of Information Technology Act. So every binary expression other than what is provided in this Schedule 1, they are covered as legally recognized electronic documents. I am sure that you are all aware that negotiable instruments other than the check means check is within the Act, but the bill of exchange and the promissory note is outside the Act. Okay, so there is this legal recognition which is there. Now, this Act again has been so forward looking that when it defined these electronic documents and along with that computers, what it did was, it did not focus on what device has been used. In fact, the whole law is not a law of computers. It is actually law on electronic documents. And whether it is generated by a device which we call computer, which we call as laptop, which we call as a POS machine, which we call as mobile, anything else, that is immaterial. As long as the document is expressed in binary form and the device can process that binary form, that is, it can generate, it can store, it can transmit a binary document, that is called a computer, and this binary expression is called an electronic document. And it also says that sometimes there could be documents which are meant to be processed in a computer or have been processed in a computer or being processed in a computer. Okay. Now such documents are also electronic documents, which means that certain printouts and certain input documents such as the OCR input papers, they are all actually recognized as electronic documents. In the olden days, we used to have these computer cards which are having holes or something like that, which we used to feed into the computer, and where there is a hole, perhaps light will go through, where there is no hole, light will not go through, and the computer recognizes that and processes it as zeros and ones. Now that card would be an electronic document. So Indian law recognizes this need to widen the definition of electronic documents from those who are only looking as a document which lies in the computer, hard disk, etc., to many other documents. Similarly, when we talk of a computer, the peripherals are also included as the computer. So even a printer becomes part of the equipment which we call as computer, and computer includes computer network, the routers. So that way our law has taken care of the provisions which will be extendable to the current generation and probably into the generation where you have AI, ML, quantum computing and so on. Now coming to the digital signature or authentication of electronic documents, the Information Technology Act has provided section 3, which has been there since 2000, and 3 capital A, which was added in the year 2008. Section 3 defines what we call as a digital signature. and section 3A, which talks of the possibility of something called a e-sign, which actually came through a schedule notification. Now, both the digital signature as well as electronic signature, which is an umbrella name given to the legally recognized way of authenticating an electronic document in India, consists of a method which uses hashing and it uses what we call as asymmetric crypto system. So a system which uses hashing as a technology, asymmetric crypto system as a technology in a combination in such a manner that this combination captures the document to be signed and also captures the identity of the person who is signing. That system is called the digital signature in India. So actually a digital signature by definition today means it is the hash value of a document encrypted with the private key of a person, and a digital signature always is referred to as digital signature of a person of a document. So that system is one which has been adopted in India. Any other form of authentication of electronic documents, including passwords or even biometrics, they are not called legally recognized digital signatures in India. Similarly, this digital signature which is there as per section 3 will become legally recognized only if behind the issue of this digital signature capability there is a licensed certifying authority. In India we have something called a controller of certifying authority who issues licenses to certifying authorities, and only such license certifying authorities have to provide services to public to empower them to apply digital signature using this hashing technology and asymmetric crypto system. Any other organization, however big the organization is, whether you call it as an MNC or not, if they are not licensed in India as a certifying authority, the digital signature systems issued by them will not be considered legally acceptable. So whether it is Adobe Sign or anything else, they are not legally recognized digital signature system in India. Passwords have never been a digital signature system, but confusions now are because some DocuSign or Adobe Sign, they come up with their own systems and call that as digital signature, and we in India get confused whether it is legally recognized or not. But Indian law, ITA 2000, is very clear that only if a certifying authority is licensed in India and he issues the digital signature certificate which specifies what hash algorithm is to be used, what asymmetric crypto system algorithm to be used, and what kind of KYC it will do, etc. That alone is the valid digital signature system in India. The e-sign, which is a new provision which was introduced after 2008, of course 2008 it enabled, and it was not until around 2015 that a system actually came into being. It is actually uses same technology as digital signature, that is hashing and electronic documents, but the difference between the digital signature and e-sign is that digital signature is supported by a certificate which is valid for multiple transactions and normally for 1 or 2 years, maximum can be up to 5 years. E-sign, however, is supported by a digital certificate which is valid only for one transaction, and that is also valid perhaps only for 30 minutes, and it is used for real-time transactions where on the fly you have to apply digital signature for a web document. It uses Aadhaar-based eKYC system. So in effect what it means is that when you encounter a document on the web and you have to apply your digital signature, you actually invoke the system where you provide your Aadhaar ID and the certifying authority will use that to immediately verify your identity and then issue a digital certificate temporarily providing you the ability to apply digital signature, which is the e-sign, and your transaction can be completed in the same session. So that is e-sign. It is less expensive compared to the digital signature. It does not require a token or something like that. So government thinks that it is useful to have this e-sign as an adjunct to the digital signature system, and perhaps provide for this authentication of electronic documents. So therefore, we have a legal recognition of document, a legal recognition of the signature. So you can create your offer, acceptance, and write any contract other than those contracts which I already stated as not the legal documents which are outside the purview of Information Technology Act, like will, power of attorney, etc. So contracts can be struck in digital mode, any type of contract, irrespective of the amount, etc. When it comes to the time, law says that how to determine the time when a message is deemed to have been sent, deemed to have been received, then where from it has been sent, where from it has been received. These things, there are certain specific provisions. Either the contract itself can state that this contract is valid from such and such a day, it is valid as if it is jurisdiction is so and so. But if the contract does not specify the time and jurisdiction, then you can use whatever has been suggested in the Act as to determine the time and the place. And as I also told you, the effect of automated system has been factored into by saying that the actions of an automated system is attributed to the person who caused it to be so. As far as the time determination is concerned, the time a message is sent is the time at which it leaves the custody of the sender. Then the time when it enters into the recipient's email box is normally considered as the time of receipt. But what happens in some cases is that a receiver may have multiple email addresses. Then what the law says is the person has to designate an email address for contractual communications, and if the sender has sent the message to the designated email address, then the receipt occurs at the time the message enters the system. But if the sender sends the message to a secondary email which may also belong to the same person, the time of receipt occurs only when the person goes and opens that email inbox. So therefore, in terms of striking a contract, one has to be very careful in ensuring that the designated email address should be made part of it. Otherwise, you may have many valid contractual responses lying somewhere in the company's email, which is perhaps not used as frequently as it should have been. So this kind of intricacies of digital contracts are available in Information Technology Act. Now, many times, many businesses try to look at passwords as a system of authentication. Most of the banks are trying to do that. Please remember, it is not recognized. Biometric is not recognized as digital signature. OTP is not recognized as digital signature. And also you must understand that in US and other places and regularly on the internet, we have something called a click wrap contract. That is, you go to a website, there is some document there, at the end of it, there is a button, I accept or something like that. You click on that, people think there is a contract. That contract will not be considered as a documentary contract in India because it is not signed the way it is recognized. It will, of course, be considered as an implied contract because the intentions of the parties are there. But the difference between an implied contract and a documentary contract is the detailed clauses of the contract may become questionable, voidable. One of the persons may say, I never knew that this clause is there in this particular document. So courts will recognize that. And particularly if the contract is between an individual and an organization, the organization which is considered more powerful and it is issuing this contract with a condition, either you sign as I am saying or my service will not be available to you. That is called actually a dotted line contract or a standard form contract. In such, that is, it is not negotiated contract like between two equal parties. In for example, you are a trading partner, every clause is debated. I say that this is what I am going to give you, other person says no, this should be changed like this, and this person says okay, I will change it like that. The other person says I will pay you in rupees, this person says no, pay in dollars. So each particular part of the contract is negotiated, but in a standard form of contract that is not done. One party, basically the dominant party, says here are the 50 clauses, you accept it in toto, then we will go ahead, otherwise no contract. So that is called a standard form contract. Most of these online contracts fall into the category of implied standard form contract. The risk there for the company is that courts may hold that your contract cannot be considered as equivalent to a documentary contract, and there will be certain onerous clauses in the contract which will not be considered as binding. These are some of the things which we must remember when we talk of Information Technology Act as representing the digital contract system. Okay, so this is about digital contracts. Before we go into the cyber crimes, if Sagar wants to use the second poll, or at least tell me what was the first poll, because I actually gave the first poll and gave the answers in this particular section, but let us see what Sagar has collected.
I think, Mr. Navi, we are having some issues while running the polls.
Okay.
My request is that if we can carry out the polls as it is instead of...
Okay, no problem. So now, before we get into the section of cyber crimes, then another thought which I would like most of you to mull over is, what, in your opinion, is the single most important cause of cyber crimes? Is it the ignorance of IT users? Is it the negligence of the intermediaries? Or is it the greed of IT companies in shortchanging security? This is what we as a community need to debate. So without waiting for the poll, let us go through it, and we will start with discussing only 3 early cases in Information Technology Act, which gives us an idea of how cyber crimes are treated in the law. These 3 cases I have picked up because they happened in 2004 and 2008, not today, okay, when the knowledge of the law is much better. These cases happened in 2004 and 2008. Out of these 3 cases, one establishes what is called Section 65B of Indian Evidence Act, which is one of the gems of this legislation. Though it appears in Indian Evidence Act, this amendment came because of Information Technology Act, and it talks about admissibility of electronic evidence in a court of law. All of you have a fair idea that Indian law bases a lot of importance on evidence. Whenever we have a crime without evidence, the person who is supposed to have committed a crime will walk free. So evidence is important, and when the evidence is in electronic form, when will it be accepted in a court of law? That is what Section 65B of Indian Evidence Act talks about. And the Indian Supreme Court actually only recently started talking about this Section 65B, whereas in 2004, of course this law came into existence on 17th October 2000. In the 2004, actually we got some clarifications and use of Section 65B. I will discuss that case, which is called the Suhaskati case. We will also discuss the Bazi.com case, which talks about vicarious liabilities, and the Umashankar's case, which talks about adjudication. Okay, Now, this Suhaskati case was a very simple case in the sense that somebody actually posted a defamatory or obscene message about a lady in Yahoo group. To that extent, it is easy. Okay, at that time there was a section called Section 67 which talked about 5 years imprisonment for such publishing and transmitting of information which is obscene. But the problem you may see here is that this message had been published not on a paper in India where the paper could be taken as an evidence to a court of law. It was actually present in one of the many groups which were there on Yahoo, and within the particular group at that time it had some 10,000 messages. So there was this message lying there. Now to pick up that message and go to a court and say this message is defamatory to me, the person to whom wrongful loss has been occurred, or it is violation of Information Technology Act and that person should be given some punishment, was something which was very difficult to conceive. But this happened in the year 2004. Police in Chennai was able to catch a person called Suhaskati, who was a very educated person, engineer MBA. He was in Mumbai and he actually went to a cyber cafe to commit this offense. And in the cyber cafe also, he did not sign in his own name. He signed in the name of this girl on whom he wanted to send this message. So he had used impersonation. He had used an intermediary called the cyber cafe and tried to hide his identity and placed this defamatory message far, far away in the Yahoo group server. Our police could not travel to New York and try to catch this server, but still, so within 7 days from the date when the lady gave a complaint in the Cybercrime Police Station, Chennai, the police were able to travel to Mumbai, make their investigations, and then arrest this person and start the trial back in Chennai in the magistrate's court. It took about 9 months for this person to be punished, and he was given a punishment of totally 5 years of imprisonment on 3 different counts. And the evidence which was used was actually provided by me. That was historically the first certificate given under Section 65B. And this punishment or the conviction was also historically the first conviction which happened in India under Information Technology Act. Just remember this. The document was lying somewhere in the cloud. We were able to bring it into the courts in India and prove a crime. That is the robustness of the law as drafted in 1998-2000, not today. So we had this, you can say, the strength in the law right from the 0 day when this act came into effect. Now today when we talk of cloud storage, anything happens in the cloud, I don't have to go and actually seize the cloud server if a crime happens. There are various ways by which, sitting in India, I can always bring that evidence into the court of law. And this provision of Section 65B is going to survive even if our classical computing switches over to quantum computing, where the definition of data itself will be something very complicated. Okay. Now, the second most important case which we have to have in the back of our mind is the Basel.com case, where the intermediaries were shaken. This is again a Delhi case. Today, this Basel.com has been taken over by eBay.in. There was a CEO of this company, was a US citizen of Indian origin. He and his general manager were arrested under this particular case, which actually involved a student of IIT Kharagpur placing a video for sale in the P2P platform, okay, C2C platform, okay, and this person sold only 5-6 copies, but the fact was that whatever he sold, which was an electronic document, and it had what we humans consider as obscene pictures, and it was considered as publishing and distribution of obscene electronic documents, and under section 67 this particular person was charged, and therefore case was filed against this IIT Kharagpur student. But simultaneously, the Delhi police also recognized that this Bazi.com had facilitated this crime by giving a membership to this IIT Kharagpur student to host this particular message and attract clients through Bazi.com platform and then distribute this video. And therefore they said, you are an intermediary who has facilitated this crime, you are part of this crime syndicate, and therefore your CEO is equally liable as this boy for this punishment. So the general manager who was in charge of the business and the CEO who was actually residing at that time in USA and came to India to make inquiries about this case, both were arrested, and it took about 7-8 years for them to convince Supreme Court that technically they should be discharged. They were finally discharged, not because they were acquitted as not guilty, but because the police had not perhaps built up the case properly, and for various other reasons they were happily discharged. But the fact was that it took 7-8 years for them, and fighting at the Supreme Court, and it must have been not only financially very expensive, but also a trauma for these two executives. Okay, but this highlights what we call as due diligence, which I am going to elaborate a little later, as the need of organizations to implement as part of the compliance. The third case which we have to look at is the case of this Uma Shankar versus ICICI Bank, which of course was handled by me as on part of the victim in the two courts in which it has passed through, and now lying in a further appeal on a higher court. So here what had happened was phishing had happened, and this customer had lost about 6 lakhs. And this was also a case of admitted phishing, in the sense that this person had told that, yes, I got some mail, I thought it was from ICICI Bank, so I answered it, and while answering I gave whatever information was asked by that particular email. So it was a case of an admitted phishing, a classical case in which the bank will always take a stand that the customer is a fool, he has given away his password, how can I be held responsible? But we were able to convince both the adjudicator in Tamil Nadu and also the TD SAT in Delhi to somehow come to a conclusion where both the courts held that this bank is actually responsible for this loss and not the customer. Okay, of course, the whole process took quite a long time. Though the adjudicator decided it in 2010, it took up to 2019 for the TD SAT to be able to give its verdict. But both courts gave their verdicts in favor of the customer, and subsequently a couple of more judgments TD SAT has given in favor of the customers, and this has redefined the concept of negligence. And what it has proved is, if a bank, in this case it's a bank, it can be extended to others, if a bank does not follow the guidelines under Information Technology Act or under the RBI guidelines, that will be considered as assisting the commission of a crime. And as an abettor to the crime, the bank will be held liable. That has been the verdict in this Uma Shankar versus ICICI Bank case. Same thing can be extended to other cases where, for example, there are sectoral regulators, they have got their rules and regulations, and the person who is in that sector may not adhere to those sectoral regulations or the general law, in which case these organizations will be held liable like Bazi.com, and when the organization is held liable, the CEO is in danger of being put in jail or made to pay compensation. Of course, ICICI Bank case is a civil case, but a similar concept in the criminal case means that if the organization is a abettor of crime, then the CEO of that organization and the persons who are in charge of business are liable and can be considered as guilty of the criminal offense. So that is the significance of this regulation. In fact, what was very noticeable in this particular case is that the so-called phishing email, which the bank said that this is a phishing email, this boy who was an engineer, chemical engineer working in Muscat, was not able to recognize that it is not from the bank. That email, of course, emanated from customer care at ICICI Bank, and the phishing URL, I don't know whether you can see the URL in the screen. In the last line, if you see, the phishing URL belonged to ICICIbank.com. Okay, so there was a doubt whether this was actually a phishing page hosted outside the bank, or somebody within the bank themselves could have created this, or as it has happened in many other cases, the hacker had first hacked into the server of an organization, hosted certain malicious pages there, and from there committed his act of crime. So that was the significance, because the security professionals of ICICI Bank perhaps took care of their access system and other things as per ISO 27001 or whatever is that, forgot to look at their domain hosting capabilities, which perhaps could have been done by a marketing team which doesn't know about too much of security. They created a website and there was an FTP login, and somebody was authorized to do it, and maybe the hacker might have compromised the FTP person's password, then got hold of the web server and hosted these kind of pages. In fact, there have been other instances also. People who have heard me in other things know that I have quoted somebody else in some other similar situation where the particular organization's web server hosted certain other documents which were used for commission of crime. So that is happened. That could have happened here also. But what the courts also looked at was that ICICI Bank was normally sending their bank statements with an email ID called customercare@icicibank.com, and the phishing mail also came from the same customercare@icicibank.com. So therefore, from the point of view of the customer, there was no way he could distinguish. In fact, even today, ICICI Bank uses customer.care@icicibank.com, which means that the users of bank system today also will find it difficult to distinguish between customercare@icicibank.com and customer.care@icicibank.com. So how we use the identity of an organization in external communications, they determine whether you are assisting the phishing criminal or you are an innocent victim yourself. Most of the cases, people like us feel that the information security managers of companies are so ignorant of the law, or they are having no concern for the customers. They don't take care of all these things. They say that let the customer look at the header information, find out whether the email has come from Nigeria or from my banking server. If he has not done, let him bear the responsibility. That argument will not be accepted by the courts, and therefore the liabilities will fall on the organizations. So organizations should not ignore basic security hygiene. They should not be complacent and should not let impersonators act with impunity. If they do, people will be going to the court and say it is because of their negligence that this happened, therefore they should be considered as abettors of the crime, and that is what TD SAT has decided in the Umashankar's case, that this sort of negligence should be considered as coming under section 43G of Information Technology Act, which talks about if anybody assists another person in committing a crime, then he will be liable. So this negligence should be considered as assisting another person. So that is the lesson which we take out of this. Since then, there have been many convictions, but we can still say successful convictions are few, very few. But people like us always say that whatever has happened, they show that Indian law is proved as a robust law. Probably some advocates may not know how to represent a case in the court. Some judges may not know certain implications of the law. Therefore, wrong decisions come. Wrong decisions come not only from small courts, even from Supreme Court. The very Shreya Singhal case, much publicized Shreya Singhal case, which resulted in Section 66A being scrapped by Supreme Court, in my opinion, was a wrong decision of the court. Then there was this Afzal Guru case in which Section 65B was ignored, was wrong, and Supreme Court itself corrected it subsequently in the PV Anwar and Bashir case. But even after PV Anwar and Bashir case, there came something called Shafi Muhammad case, in which another smaller bench of Supreme Court gave a decision which was different from what PV Anwar bench had said. So the courts themselves are still learning after 20 years. Okay, so companies could be behind, but this is the time when we have to realize that we have to reduce such mistakes and ensure that the law is respected, and we know that if the lawyers presenting the cases are good and if the judge is reasonable in hearing to these lawyers, you will get into problem if you are not following the law. Okay, but challenges will remain. And why do these challenges come? I'm sure that many of you are from the technology field, not necessarily legal field, but I would like to say that we as people sometimes tend to be combative with law. We don't respect law. If law is made, we say why it is there. So we are seeing a lot of arguments about this Data Protection Act itself. That is an indication. Law enforcement also has not developed a trust with industry professionals. So we don't trust the police. We don't trust the law enforcement. Okay. So sometimes we also get struck with some rigid technical perspective of an incident, and we are unable to see the multi-dimensional view of cyber crimes. That is why if you want to appreciate cyber law, you must first of all accept that there are different perspectives for cyber law. A victim of a cyber crime who has suffered a loss either for his reputation or property, his concern is to recover the money, get the culprit punished. That is his objective. Lawyers, police and judges who form this law enforcement, they try to prove an offense in a court with appropriate evidence, otherwise let the person go free. And if it strikes them, they would like to get punishment to the offender, so they will always be looking at the law, whether it is a 2-year offense or a 3-year offense, whether it is cognizable, whether it is bailable. That is the focus of a lawyer. For the victim, that is not the focus, whether it's 1 year punishment or 2 years punishment or 5 years punishment. Where do I get my money back is what the victim will be looking at. Compared to these two, the managers of businesses, the IT, IS professionals, even business professionals will be looking at cyber law from the perspective of, does it say something about what information security practice I have to follow and how I can avoid a Posi.com situation in my organization? That is the perspective of the corporate entity. And there are, of course, professionals who get into forensics and other things. They will try to go deeper into finding out the evidence, etc. So, different people will have different perspectives of cyber law, and likewise, technology people also will have a different perspective. See, in fact, in my opinion, the technology people who do not understand the their responsibility to the society are some of the biggest people, I can say hurdles for these cyber crimes. There is what can be called as technology intoxication of technology people. An example is right before you. This happened very recently. A techie in Bangalore actually made a big claim that government has come up with an Arogya Setu app. I don't like it. Okay, he doesn't like it. But what he did was he tried to find a way of hacking that Arogya Setu application, and even then he did not keep it to himself. He went about bragging everywhere that this is how you can hack into Arogya Setu and see that your information is not available, something like that. And this same kind of thing had happened about 10 years back, and I had pointed it out at that time. There was a senior IT professional in Hyderabad belonging to the Satyam group who had developed a sort of a script for hacking into IRCTC reservation system. When I say hacking, he did not want it to make money out of it, but he wanted to actually give out that script free to people so that they can override the security aspects of the IRCTC server for booking the tickets. Same way, he also published it in his blog and said that anybody can download and anybody can use this. This kind of attitude of doing something which legally is considered as hacking, and more so developing a hacking tool and distributing it to hundreds of people, that is a much, much bigger crime. And these crimes are being done out of ignorance by technology people, as if they are intoxicated with the power they have out of technology. Okay, even today, whenever a government comes up with an app, there will be 100 technology people who are only interested in breaking into that app and to say that this government does not know how to make apps. After all, it is not the government Babu who does that app. It will be another technology person who would have done that app. So you are going to criticize another technology person. Basically, we are having a sort of a attitude of hacktivism, and that is how we have cryptocurrencies, we have got the deep web, because of which cybercrime control has become more and more challenging and difficult for law enforcement, because there is no cooperation from the technology sector to the prevention of the cybercrime. This is a big statement I am making. Many of you may not like it, but I am talking of it from out of my own experience. I am not saying that police don't make mistakes, police don't misuse the law. They do misuse the law, but at the same time, technology people don't come out openly to assist the law enforcement to prevent the crime. Otherwise, there are few very good police officers. You give them proper support, any crime can be perhaps reduced, or crimes can be reduced in totality, and something can be done to improve the society. So that is technology intoxication. The second aspect is that sometimes we have an inability to look at an incident from these different perspectives. One example I would like to give is this recent Pnb fraud. It is a bank fraud, so 11,500 crores were lost. But when you go deeper into it, there are various ways of looking at this kind of a fraud. The technical perspective is, how is it possible for a bank running a core banking system to have 11,500 crores of lending without that transaction coming into the CBS? I am an ex-banker. I know that even if 1 rupee difference is there in my general ledger, we will be burning the midnight oil to find out why this 1 rupee mistake has been there. Now 11,500 crores over a period of 9 years has been there, which shows that the technology which was given to this PNB was defective technology. Now, technology people may say that technology is a tool, how you use it or misuse it is your responsibility, but when somebody develops a technology and gives it out to a bank for public service, they should know that they have a responsibility to ensure that what they are selling is not a tool with which public can be scammed. Okay, so in this particular case, the company actually sold a CBS system, did not link it to the SWIFT system, so SWIFT messages could go independent of the CBS system. Therefore, this fraud could have happened. It is a technical failure if you look at it from that angle. Of course, there was cybercrime perspective is there. Somebody made money, somebody helped him make the money, the bank officers were involved, so that is cybercrime perspective. The management perspective is now how do we recover the money lost, how do we recover, what will be the NPA and that kind of a thing. So when an incident takes place, there are different ways of looking into it, and then only you will be able to understand whether Information Technology Act provides a proper solution or not. Even if you take this Uber car accident where a person died, there are various ways of looking at it. Technical perspective, maybe what caused the failure, did any processing chip fail, or whether any sensors failed, or whether there was a mechanical failure, the brake was applied but it did not stick or something like that, or was there any hacking of anybody. Okay, so there are various ways of looking into it. And also from the managerial perspective, we have to see what happens to the future of driverless cars. So again, I am only highlighting that when an incident takes place, we have to see how different people have to look at it differently. So even if you take this simple phishing, which is very common, I will say that not all of us will look at it in the same way. Bankers will say it's customer's negligence, and customers will say it is banker's negligence. So I had to recently bring this kind of clarity in the court of law, where I said that phishing doesn't result in financial loss directly. Phishing is only impersonation of email, using a false email or a false website. There is a cheating, defamation. All that leads to stealing of the password. Now there phishing ends, and that all happens in the customer's place. But then somebody takes an unauthorized access to the banking system, he creates a beneficiary, transfers the money, all that happens in the paying banker's place. And funds withdrawal takes place at a third place, which is another bank. So there are three different places where the common banking fraud, which we call as phishing, happens, and there could be negligence of the customer in the first place, but there is also a negligence of the banker at the paying bank, negligence of the banker at the collecting bank, and that is the reason why we were able to convince the court that this is a fraud which has happened due to multiple people showing negligence, and whoever was last responsible for the commission of for the loss to occur, he should bear the loss. So this kind of rethinking has to occur in changing the narrative of cyber crimes, in which the technology people have to assist, particularly the journalists who write some kind of headline which comes to their mind. Now, again, to appreciate the Information Technology Act, we must see that in 2000 or even 1998, we had not heard of ransomware. But today, if a ransomware attack happens, the question which will come is, does Information Technology Act have something to say about ransomware? I would say yes. You can consider it as unauthorized access, denial of service, introduction of a computer contaminant. There is section 43, section 66, maybe many more sections. And if the system is a protected system, there is a 10 years imprisonment. If in certain cases, if it is a system of banks, etc., you can even call that as cyber terrorism and bring the culprit to a trial with life imprisonment. So, Information Technology Act has this robust nature of addressing the cyber crimes. The beauty of Information Technology Act lies in first, the focus on electronic documents instead of computers, defining electronic document in a universally acceptable manner as binary expressions, extending the scope of definition of electronic documents and computers to paper documents and peripherals, defining section 65B for digital evidence, defining attribution to be applicable even for AI and ML situations, defining reasonable security practice to be a contract-based aspect, and defining due diligence to include environmental changes before something becomes a formal law. These two aspects I will slightly extend in the last section of this presentation. Okay, so with this, that there are cyber crimes of various kinds happening. Law was made in 1998. People are happy to criticize the law, but I am saying it is robust enough to meet many of the current requirements. Now let us see what ITA 2000 did correct. Okay, what they did was, there are two kinds of ways we look at cyber crimes. One is there is a chapter 9 which talks about civil wrongs, where the law says that if somebody has suffered a loss on account of a contravention, compensation has to be given by the other person. That is the Umashankar kind of case. Chapter 11 consists of certain acts which, if it is done, a person may be put in jail or he may be asked to pay fine to the government. That is called criminal offenses. So the civil wrongs are normally going into a civil system of judiciary, which starts with adjudication, not the normal civil courts. Up to 5 crores the adjudicator takes care of it. From adjudicator it goes to the appellate tribunal to the high court, and then the Supreme Court. Criminal offences, of course, are prosecuted by the police and they take it through the normal criminal route. And there is one section called 43 in Information Technology Act Chapter 9, which is a combination of 10 different kinds of contraventions which literally cover everything you can think of as cyber crimes. It covers unauthorized access, unauthorized downloading, unauthorized introduction of computer contaminants, unauthorized causing of damage to a computer or a computer system, causing disruption, causing denial of access, providing assistance to contravene to somebody else, then using a service and shifting the charges to some XYZ or somebody else, or in some way diminishing the value of information residing inside the computer, or even destroying the computer source code. All these things are covered under section 43, and liabilities are fixed on the person who is responsible. And this 43 is linked to a criminal section called section 66. So if it is done with malicious intention, then section 66 gets invoked, 3 years imprisonment is there. If there is no malicious intent, it will be only a civil claim. In 2008, government added this section called 43 capital A, which was a data protection requirement. So since then, ITA 2000 has doubled up as a Data Protection Act of India. We should not say there is no Data Protection Act of India today and only it will come when PDPA is there. No, it is already there, and this 43A addresses what is the sensitive person information, and if a company is processing a sensitive person information, they have to do what is called reasonable security practice. They have to implement reasonable security practice, otherwise they are liable to pay compensation. Now, what is this reasonable security practice? Basically, the first step is there a contractual arrangement with the data subject and the company, either directly or through another agency, and that will determine what is a reasonable security practice. If necessary, if there is a law, then you go back into the law. If there is neither a contract nor the law, then certain best practices in the industry, such as your ISO and other things, will come in. Otherwise, the first two aspects will take care of what is a reasonable security practice. So, compensation either under 43 or 43A will be given by the adjudicator. Adjudicator is the IT Secretary of State, and up to 5 crores, he is the sole authority. Beyond 5 crores, it will go to the Supreme Court. I will take another 5 minutes and then we'll get into the questions. Okay. Then, as far as the offences are concerned, there is a big list. I will not be going into the entire list, but there are offences related to data damage, which is the section 66, 72 and 72A. Offences related to obscenity, 66E, 67, 67A and B. Offences related to digital signatures. There are offences related to information security obligations, 69, 69A, 69B, 70B, and 69 and 69A may even have very big imprisonment terms. There are offences related to evidence, section 65, 67C, data retention. Then there are offences related to use of stolen systems. There is some systems which are called protected systems, something which will lead to cyber terrorism. There is also what is called vicarious liability, where offence is committed by one person, but the liability has to be also borne by somebody else. That is the Basel.com kind of a situation. There is also something called abetment and assistance, which is covered under Information Technology Act. So it is a fairly big cybercrime law. It was a digital contract law first, and then it was just a second. I will have to put the cable for power. So the it's a comprehensive law for contracts in the first place, and then the cyber crimes in the next space. Now we come to the last section, where ITA 2000 seeks the cooperation of the industry for cybercrime control through mandatory compliance. What we call as ITA 2008 compliance, which we say that if you don't comply with this, you will be put into jail for 3 years, 5 years, is only an indication that the government is giving to the industry that you are in a position to secure the cyberspace. Don't expect the government to actually bring cyber warriors to protect the cyberspace. Cyber warriors are there within every company, particularly the intermediaries. Okay, so what the law says is, you have to be compliant to certain aspects which we think should be done, and that is necessary, otherwise we will put vicarious liabilities to you. So the threat of vicarious liability should not be taken as a reason to fight with the government, but it is something which the government is asking the industry to do so that we will be able to reduce the losses. We will skip this poll for the time being. It's on due diligence. Now I will explain it in a few slides. One is, normally when a firewall is breached, we know that information could get damaged. But remember that behind the information there is somebody called the information owner, who may be the shareholder or whatever is that. So whenever a breach happens, ultimate loss is also felt by the information owner. Now what we are saying is that all these technical measures of security try to focus on how to preserve the confidentiality, integrity and availability of information. I am saying that that should not be the end objective of any information security program. You have to remember that whenever information is damaged, you may be able to bring it back to your DRP, BCP within a few minutes, but the damage to the person who is the owner may not be recovered as easily as your DRP system can recover the last message. Say, today if a company has been attacked in a ransomware, they might have come back with their servers being reset or something like that. But the $50 million they have lost is a loss. Okay, so that is to be recognized by security people. That's why we say security is incomplete if it cannot protect the data owner. Don't stop at protecting the data, protect the data owner. This is what the law says in terms of section 85 and section 79. It says we will have vicarious liabilities on companies and companies executives and the intermediaries who pass messages through, and that message could be used for crimes. Now, vicarious liabilities will not be applicable if an organization follows due diligence, but it has to prove. Proving due diligence is the ultimate message of ITA 2000 to corporate executives. I am not interested in looking at Information Technology Act for lawyers who will fight a case in the court. They will fight for either parties. A person who thinks he is lost the money and the person who has gained the money. For both, lawyers will be fighting. So obviously one of them is wrong. They are not honest at all. But for the companies, we have to see that due diligence is required because we need to protect the society. That is the responsibility which is there. It's a management's responsibility to have an infrastructure which protects the system in such a manner that no crimes will happen in my system. That should be the objective. And that can be done through policies, procedures, documentation of activities, introduction of antivirus software, other controls, IDS, firewalls, etc. So it covers technology, covers law, and it also ultimately looks at how people accept it and run it. So that is the three dimensions of information security, which we call as techno-legal information security. So the essence of due diligence is proper disclosure in terms of privacy policy and terms, do's and don'ts, reasonable security practice, maintaining of evidence, having a good grievance redressal mechanism, which includes designating somebody as the compliance officer, then having an incident management system which is oriented to techno-legal aspects, not only technical aspects, and then conducting a compliance audit from time to time and documenting. Remember, ITA 2008 is a huge law. It is a Cybercrime Act, it is a Data Protection Act, it is a SOX, it is a Digital Contract Act, it is Patriot Act of India also. So all these things are ingrained in Information Technology Act, and corporates need to comply with it by recognizing that there are different kinds of risks they can identify solely from Information Technology Act. Data privacy risk, retention risk, information demand risk, authentication risk, and so on. These are the things which perhaps we'll discuss on some other day, but I'm only saying that information technology people need to look at the act with a different viewpoint to identify where are the risks and what should I do to mitigate that risk. For which you can have your own framework. This is a framework which I normally use, where I recognize that it is not only the IT people who are responsible for compliance, but from top management, middle management, HR and business, different aspects of compliance controls are required. This particular framework takes into account the three-dimensional approach involving technology, law, and behavioral science. It recognizes an enterprise-level collaboration requirement. It recognizes the importance of motivating the people. It recognizes the need to make corrections through periodical changes in a dynamic situation, and perhaps a need for an open standard which is homegrown and adopted to meet the Indian legal framework, rather than just importing what is there in some other international scenario. So you people who are in information security need to move beyond DRP and BCP towards what I call as defensive legal protection and offensive legal remedy. This will be the techno-legal approach to information security. Of course, this is an introductory session. For further information, you can visit my site navi.org or fdppi.in. You can contact me over email or otherwise. You can also read my books. So now we will close this session and take whatever questions you have, any amount of time you want to spend. Okay.
Thank you, Mr. Navi, for taking that wonderful session. And it was really nice session and a really, knowledge enhancing session for us. And we have quite a few interesting questions signed up with us, which the participants have been sharing with me during the course of the session. So I'll pass on those questions one by one. I'll share those questions with you. So first question is coming, which says that normally when we work in office, a lot of approval happens over emails, and a lot of agreements and contracts also gets approved over emails. They may not be necessarily digitally signed, right? So in terms of legal aspect, what is the validity of such contracts and agreements, and whether they are enforceable by law or not?
They are equivalent to what I called as implied contracts, which is let us say a second grade contract. Like slightly better than oral. Okay, so like oral contracts are also acceptable in law, but these contracts, they appear to be in writing, but when you go to the court of law, the document will be just thrown to the dustbin. If the other party objects that this is not a document which is admissible as evidence, okay, the court may not take it. Today we are talking of admissibility, if section 65B certificate is there or not there. Similarly, contracts also, if it is signed or not signed, it may lose validity, but it will have validity as an implied contract. So we have to build some kind of an evidence around this, so that in the court you can give ancillary evidence. Like in a oral evidence, we sometimes bring witnesses. The purpose of witness is to say that I know this person signed this contract. Likewise, you have to bring electronic evidences in the form of witnesses to prove this. Otherwise, you are having a risk. That's all I can say at this point of time. So it is not equivalent to a digitally, like a signed paper document. Okay?
But to be on the safer side, it's always better to get the document digitally signed.
Correct.
To be on the safe side of the law.
Yeah. And it should be digitally signed as per Indian law, not because it's Adobe sign or something like that.
Right, which means that the CA has to be he has to be Indian authorized CA.
Yeah, it should be done by an Indian licensed CA.
Right.
Yeah.
Yeah. So another question which we have is that how critical and sensitive is an IP address to any legal case, and especially in terms of justifying a location if a legal case comes up. Then how important is IP address?
It is important as the first prima facie evidence of the origin of a message. But the counterparty will always talk about how IP address can be spoofed and other things. So it has to be supplemented with some kind of a support. But as a first prima facie evidence, yes, it has got its value.
Another question which comes to us is, this question is from, just give me a second. That as of now, we don't have any legal provisions around data retention policy. We don't have a clear timeline in the Act as such. So how do we maintain that the data is retained appropriately in any organization, and especially in BFSI sector?
Say section 67C talks about data retention, that a company should have a policy for retaining it for a reasonable period of time in an appropriate form. There is no notification under that, but it is open to the user, like the organization, to develop a policy and say, this particular document I will keep for 3 years, this will keep for 2 years, this will I keep for 7 years. They may have to take, if any, other law. Like if you are talking of BFSI, if there is any other law which says a document has to be kept for 20 years, you have to keep it for 20 years. So where there is a law, we will adopt that. Otherwise, the company has to have its own data retention policy. You cannot just close your eyes to the fact that there is an act, section 67, but there is no notification. It doesn't mean that for every section there has to be a notification. The act comes into effect with the passage of the sections, but clarifications given in the form of notification is better. But it doesn't mean that where there is an absence of notification, you cannot say the section itself can be ignored. So my viewpoint is there is section 67C, talks about data retention. So the individual companies, for their own best practices, have to determine a policy and write it down and keep that as part of their due diligence. Now, whether they are correct or not, you can debate. Suppose you have kept something for only 1 year, for example, CCTV footage, many people will delete it within 24 hours. We say you cannot delete it within 24 hours, you have to keep it for a reasonable period of 90 days or something like that. Now, within this 90 days, if you know that your CCTV footage has got a crime evidence, we say that you should keep it forever. In fact, this came up in the Umashankar's case also. ICICI Bank had deleted an important CCTV footage. We said you have actually deleted evidence. You are punishable under section 204 of IPC and section 65 for erasing the evidence. So, like that, their organization should have their own data retention policy. Don't blame the government for not bringing the notification. Same way, encryption standards industry sometimes will be telling we need to have some encryption, but government has not come up with encryption standards. Okay, let the government not come up with that, but the industry has its own capability to bring what they otherwise call it as standards. So the act, once it is there in the section, it is applicable. Rest of it is secondary, and it can be done as an internal policy first. Then industry-wise, there can be policies, and then the government may also come up with a notification. Okay.
And one of the, just to add to what you said, one of the important indicators for retention period could be the purpose for which the data was collected initially. So if the purpose has been met, the business objectives have been met, then it's always wise to be very prudent as to whether you want to continue with the data or not.
In the Data Protection Act, we normally talk about purpose, and after the purpose is over, it should be deleted. Now we are here talking of cybercrime law. Say, when there is an evidence, let us say your company has got some evidence. I want to actually use that evidence for a legal claim. Now, civil claims, I have got 3 years limitation period. So, anytime within 3 years, I can come to you and say, please give me this evidence. I want to file a case. Either against you or with somebody against somebody else, you are holding the evidence. Now, if you say, no, I don't want to keep all this evidence, I will say your business process or the policies is not supporting the system where law has given me 3 years for making a civil case, and in the case of criminal offences there is no time limit. Therefore, this data retention should also take into account the so-called Limitation Act, and in certain cases the need for crimes, supporting crimes. In fact, even in the intermediary rules, even when you delete some information from your system because a court has given an order, you are always required to archive a copy. Say, there is a difference between cyber crime laws and the data protection laws. In this case, many times you may have to keep a secure archive of some information if you think it is a potential evidence to a crime. So we have to think a little more in depth rather than adopting the data protection principles like, okay, it is given for a purpose, after the purpose is over, cut off. So there may be other reasons. After you have deleted, tomorrow you may get a notice from some police saying that yesterday something has happened in your company. There is the evidence with you which is perhaps will be leading us to a cyber terrorism or something like that. Then if you say, I don't keep all these things, you are actually not assisting the law enforcement, and under section 69, 69A, not assisting could become a problem. Okay.
Yeah. Another question which we have is, and that's a very interesting question, that sometimes, especially in hospitals, we see that patients complain of overbilling and the bills not being as per the procedure, and sometimes they even ask for a CCTV recording of the OT room itself. But putting a CCTV camera in an OT room may result into privacy violations as well. So how do we define the thin line which is here in protecting the privacy as well as being on the right side of the evidence, maintaining evidence also?
See, all privacy laws provide for the legal right of the data subject for information. See, in this case, you are talking of, say, I am the patient, whatever you have done on me, if that information is there, if I am asking, where is the question of privacy? I am the data subject who is asking. The only person who can object is if I am in a general ward, there are other people, then other people's information get disclosed along with mine. That is an issue which he has to take. I would very quickly, I am not going for detailed answers. This case has come up in Alexa and Fitbit kind of instruments. There have been instances where crimes have been solved because of information collected from Amazon through Alexa recordings and through Fitbit kind of wearables recordings, maybe even medical implants. So police have been able to issue notices to these IoT companies, ask for the information. At least in one of the cases, the accused was the owner of the Alexa system, and therefore he himself wanted to be freed from the charge of a murder. Therefore, Amazon said that I am giving you the information because the owner of the device himself requires this information. But in another case of a Fitbit, the owner was dead. So police were trying to find evidences. They found that through this Fitbit or this smartwatch, they were able to identify that the dead body was moved from one location to another location, GPS data, and in another case, the heartbeat changes at a particular point of time was actually leading to the solving of the crime. So privacy has to yield to security. Privacy is not absolute, it is always secondary to security. Of course, your privacy cannot be breached by me, but your privacy, if you ask the organization, hospital to give the information, then you are actually changing your consent and you are demanding that. So if that is evidence, hospital cannot refuse. If they refuse, they will not be cooperating in law enforcement. Okay?
Right. And another quick question, Mr. Navi, is which is coming from Shishir Verma. So he asked us that the PDPA law already has provisions around cross-border transfer of data and protection of the data. But does the current IT Act has some provisions around it, especially with the growing cloud environment and company moving to cloud, especially in COVID times? So do we have any protection as of now in the
It was not the objective of IT Act. Okay, so it did not address that, except that it has to be kept secure. So if you are passing the data to a cloud service provider, you have to have a contract in which the cloud service provider as an intermediary is expected to keep it secure, otherwise become liable. So that kind of contractual agreements you have to build for the purpose of security. Otherwise, at that time, government was not concerned about this cross-border transfer. So it was not part of that. But banks and other things have given their own data localization requirement because they perceived that security will be affected if data is perhaps taken out of India, and therefore through sectoral regulations they try to impose certain cross-border restrictions. Now of course PDPA may formalize that.
Sure. I think we have probably one more last question coming in as we speak. So the question is that does online payment gateways also get classified as intermediaries?
See, intermediaries purely are persons who are actually persons who transit information. Okay, that is typically an ISP or a mobile service provider. He doesn't have much of interest in the data. Data flows in and flows out like a router. But whoever uses the data for their business and stores it for their business, they actually lose the intermediary status. They become users of data. So they cannot claim exemptions under Section 79 of Information Technology Act. Rather, they will be liable under Section 43A for security. Maybe some functions are purely intermediary, but any company, including banks are not intermediaries, okay? Because they take the personal data and use it for their own benefit. But within the bank, they may be doing some marketing of insurance or something like that. So there may be part of the data in which they are wearing the intermediary's hat. Payment gateway, in every one of their transactions, they are actually using the data and they are making money out of that. It is not like a network service provider who is just passing the data. So they will not be ideally considered as intermediaries. They will be data users. They will be coming under Section 43A, reasonable security practice. Okay. See, any other questions which, even if it is there in the chat box, if you collate that and send it to me, I will try to answer it and provide it back. And beyond this, I have given my contacts. I am basically an educationist. I would like to provide as much of clarification as possible so that professionals are aware of the law. So don't hesitate in getting back to me with any questions, either directly or through your ISACA chapter. Not only questions which have come up in the chat box today, which you have not had time to explain, but even other questions. Okay.